My name is Charlie Pillsbury, and I'm co-director of the Center on Dispute Resolution here at Quinnipiac Law School. My co-director, Carrie Cass, may be here, but she's not here yet. But we have the distinct pleasure to have my colleague from the Yale Law School, Noah Messing, who teaches arbitration at Yale and had a significant hand in inviting your speaker for the day. Because this is, after all, called the Quinnipiac-Yale Dispute Resolution Workshop Series. And we actually get an opportunity today to see the workshop in action because Professor Day, who I'll introduce in a minute, his article is not yet published. It's coming out this summer. So there is time to make some revisions if someone has an insight, a contribution, and then give him your name afterwards. You might even get a footnote. So we'll see. Greg Day is an assistant professor of legal studies at Oklahoma State University Spears School of Business. Before Professor Day's academic appointment, he practiced law at Morris Nichols Arston Tunnel in Wilmington, Delaware, in the firm's commercial counseling practice group. His JD is from the University of North Carolina, and Professor Day also has a PhD in political science with a focus on international relations from the University of Mississippi. So I guess I should call him Dr. Day. Currently, Dr. Day's research primarily concerns the legal aspects of markets and market failure. Often these works touch upon the relationship between human rights and business, as his topic will today. In Greg's free time, his faculty page says, he's in search of America's best barbecue. He will not find it here. But if he's searching for America's best pizza, he's come to the right place. So with that, Dr. Day, thank you very much.
Well, first, thank you very much. I really appreciate the warm entry. I also want to, of course, thank Yale Law School and the Quinnipiac School of Law for inviting me here. Everyone's been incredibly hospitable, and that is actually, in part of the hospitality that I've received, I've actually asked several people who I've just met on the street when I went out, like, what's one thing I'd be really sad if I missed, and I was told pretty much by everyone the pizza, and especially clam pizza, I was told. So that's what I was, so before I leave, I'm definitely gonna make sure to get some of that. Thanks so much for everyone for coming. This is a topic that I personally find incredibly interesting, and I mean, I guess naturally so, because why would you write a big old article on it if if you didn't find it? But this is a personal interest, sort of a personal passion, so much so that I've tried to shoehorn it into any class that I've taught. Sort of matters of human rights and jurisdiction and resolving these issues. So even the classes I've had, like commercial transactions, I always kind of try to find a day and where I have sort of confused aspiring accountants just wondering why we're discussing this or how this applies. But it's more because I just find this topic just incredibly interesting and complex, and it's also quickly moving. And also, as was mentioned, that this article is right now currently in the publication process. It's set to be published by the St. John's Law Review. But it's still actually going through the editing process. So if anybody does have any ideas, comments, no matter how trivial or global they are, there's still plenty of time to be incorporated into the work. So I do really welcome all comments and criticisms, because really I only want to produce the best possible product. Anyway, so just sort of to trace the paper and to trace the argument, but also to discuss any sort of updates and then open questions. There's some aspects of the paper that really weren't necessarily reflected into the draft that I also really want to emphasize. But first, in terms of just sort of tracing the paper for everyone who's, I guess, watching on YouTube or simply in the room, the paper responds to two very closely interrelated problems. They're not necessarily necessary or linked to each other, but generally they are. The first one is that whenever human rights abuses generally occur, the perpetrators are generally never held accountable, usually, the great many times. And the other thing that goes hand in hand with that is also the victims. And, normally, sadly to say, is not just the victims, but a lot of times it is their families representing the victims have a great deal of trouble finding a remedy or any sort of redress for their injuries. So naturally, those two things go hand in hand, because a lot of times when victims don't find a redress, it's generally because, the perpetrators are not held accountable. And this has been the way it's been for, I guess, generations, centuries, et cetera. And the primary identified reason is, well, it's a legal problem. Ultimately, this is a legal problem, and it stems from the fact that most human rights abuses occur in developing nations, and not just any developing nations, but particularly ones that have demonstrated sort of a lack of capacity or a lack of will to prosecute or litigate human rights abuses. And there actually could be many, many reasons for this, but sort of three principal reasons is A, what we said, just a lack of political will. Quite frequently, in my paper, generally focus on the business, the companies and the corporations involved in the human rights abuses. But they're not generally always the sole actor. A lot of times there is some complicity or hand-in-handness with the local government. A lot of times it's actually the local government that's primarily accused. A lot of times it's oil companies operating in the developing world have to hire local paramilitary forces that are effectively wings of the government, and those are actually the actors that commit the abuses. And because of that, you're going to see a lack of political will to act, because it would be effectively the government holding the government responsible for atrocities that, if there was political will, they likely just wouldn't have occurred in the first place. Naturally, the second aspect would just be a lack of political institutions that are able to do so. Generally, countries like Afghanistan or Somalia in the political science world are often referred to as failed states. And when we say failed states, we mean that there isn't an effective legal regime, there isn't an effective executive regime, and essentially the political institutions and the governmental institutions are largely incapable of policing and executing laws and interpreting laws, et cetera. So what this leads to is another situation where human rights abuses in those countries goes unchecked. A third is, a lot of times some countries even have some adequate political institutions, but they actually lack the laws that would be enforceable. This paper, as we'll discuss later, largely talks about Bangladesh and the Bangladesh Accord that arose out of it. One problem that happened in Bangladesh was there's a series of factory fires, and the factory fires weren't unpredictable. Everyone knew for many years that they were working in hazardous conditions. They weren't fire safe. People were packed in, and it led to great atrocities. And again, that was another situation where, when a fire occurred, one fire in particular killed over 1,000 workers in a Bangladesh factory, and none of the victims ever received much recourse. And the primary reason is Bangladesh lacks tort law, or a tort law that's based on par with what we learned. And from most of my research, it says, well, they kind of lack a tort law, something that you could sue under for things like negligence. So even if Bangladesh does have the court system to execute it, there was nothing to execute. So this has created, a general problem that, where the most natural place to litigate a human rights dispute would be in the place where it occurs. And so far what we've seen is that, that's generally not a possibility. So the next plausible thing to do would be to litigate it also in the United States. And there has been just a bevy of human rights litigation occurring in the United States, because the United States seems to have some sort of an effective legal regime. It seems like the United States is a little more willing to litigate these cases, at least on procedural grounds in the first step. A lot of the social conscious lawyers happen to live here. So and one of the biggest aspects is a lot of the corporations that are accused in being involved in the human rights abuse also perhaps are American corporations, or at least they're the subsidiaries of American corporations, which has made the United States maybe not a natural ground for these lawsuits, but perhaps a good second option, considering the impossibility of the first option, which is being in the home country. And a lot of the lawsuits that have come out that have been raised in the United States have been actually substantially interesting. And one part that makes them interesting is because the United States is not the natural place for these lawsuits to occur, it's really demanded some creative theories. Generally one is tort law. And tort law has been ineffective. And the primary reason is because if some sort of act wholly happens in another country, maybe there'd be a lack of personal jurisdiction, or you would apply the laws of that country. And either way, the courts normally will say something like, we just fail to see how the United States has any necessary contact to whatever this event that happened in this country. Another one would be contract theory. That's also generally been difficult precisely because, one, you have to actually have a contract clause that was violated, and oftentimes there simply wasn't a contract clause. And even when there is, and then also a lot of times the corporation is a subsidiary, so it's hard to sue in the United States under the theory that you're not suing the proper actor. One of the most interesting cases that came out a while was Doe v. Walmart, where Walmart actually contracted with factories in several developing countries, saying that we reserve the right to monitor the factories you have to follow certain standards, and we reserve the right to monitor. And those factories naturally decided not to abide by those standards. So you had the victims and the injured parties who were factory workers in Latin America, Africa, and Asia, suing basically on a contract breach theory. And part of what they said gave them standing was they were third-party beneficiaries because those terms in the contracts demanding a certain level of factory standards were meant to protect them, giving them right to sue in the United States. And not to go too deep into contract law, but they were suing Walmart, and Walmart had only reserved the right to monitor, and they didn't actually, which they didn't breach. But the point of bringing just that litigation up is to show the real creativity that is being constantly used to try to hold these companies liable in the United States for acts occurring solely in other countries. Probably the most famous example is a lot of times statutory remedies. Especially what people probably know the most about would be the Alien Tort Statute, which arose out of the first Congress, I believe I forget the year, but it's simply a one-sentence statute from the Judiciary Act, I believe of 1789. I hate to get that wrong and be on YouTube, but nonetheless, here we are. But one problem you have with most of the statutes is, and this is another problem I have, is saying the word extraterritoriality. So I'll probably say it a few times. My tongue and mouth cannot form that word very well. But nonetheless, there's a presumption that statutes do not have application in other countries. So when you try to sue based upon events happening in other countries, the United States has to have some authority to act. And when we pass statutes, the Alien Tort Statute lacked an extraterritorial statement, giving the rise to the presumption that it only meant to govern events that happen inside the sovereign United States. There was another, I believe it was the Torture Victims Prevention Act, which governs a lot of human rights abuses, including like murder and torture, and one of it would be like slavery and trafficking. There was a group of Rwandan factory workers working for the Firestone plant in Rwanda, and they alleged that they were effectively trafficked into the Firestone plant. Along with that, they were given to the factory by local chiefs and essentially enslaved. So they sued underneath the statute. When the statute lacked, of course, that statement giving extraterritorial extension. And again, remember saying where they have to make these really creative arguments to get inside the United States. And they had a really creative argument as well. Their argument was that this statute governs human trafficking, which is almost inherently an international phenomenon. Because of that, it would be absurd to read the statute and to say this doesn't apply to the United States. Well, the court again, and very predictably said, nope, it needs that statement because otherwise we're governing an act that occurred in Rwanda solely by Rwanda. And if somebody should act based upon this, it's up to Rwandan authorities to mitigate this. One thing that might immediately pop in people's heads is again, well, how about Firestone? You have a series of American corporations, but so long as they're subsidiaries of the parent corporation, we separate the corporate existence. And we say, so these are essentially Rwandan or other international corporations acting inside Rwanda. And again, you have a scenario created where there is no human rights remedy or recourse that could possibly be given. And this has represented what this has looked like, what sort of the general landscape for quite some time. And just before I forget, the case where it was held the Alien Tort Statute doesn't have extraterritorial extension was Cable versus the Royal Dutch Petroleum Company, when a group of Nigerian oil workers said that, I guess there was villagers who were protesting, said that the oil companies had used the Nigerian military and sort of security forces to forcefully crush a peaceful resistance and rising to things like extrajudicial killing. So this is really the stakes that are on the line. I mean, this is not sort of a small potatoes human rights abuses, but we're talking about sort of the highest levels of human suffering, and there is no recourse. And so far, there has been no remedy. And if you take a look through the literature, the normative aspects of this have not gone missing. The amount of student notes that were written and the amount of articles just, in terms of law reviews, or also just the popular press just decrying the Supreme Court for basically what they said, like legalizing human rights abuses by not allowing the Alien Tort Statute to survive, with this extraterritorial jurisdiction, that essentially the Supreme Court has just undermined, respect for human rights. And I understand why these concerns exist, because essentially, I guess you could say this is the natural implication. But one thing that should be mentioned is when the Supreme Court ruled that the Alien Tort Statute doesn't apply, it wasn't what people normally assume is one of those 5-4 decisions. It was a unanimous decision, agreed upon by each justice. And the reason why I bring this up is because there actually is substantially good reason why U.S. courts have a significant difficulty litigating foreign human rights. One thing is, and as I mentioned, I was formerly a political scientist, and when I did political science, I did international relations, and part of that was international conflict. And when we studied international conflict, when I did, one thing that was really important is the fundamental question of why do wars happen. And throughout history, one of the ideas why wars happen is simply countries messing in other countries' affairs. This goes back to sort of the Treaty of Westphalia, where there was centuries of European wars, and it was oftentimes thought that the reason why these wars were occurring was because countries were meddling in each other's business. Back then, the primary reason was religion. One country wanted to be Catholic or Protestant, and through sort of meddling in each other's affairs, conflict arose. So since then, that was sort of the creation of the modern day idea of sovereignty. And under this idea of sovereignty is each country has the right to govern its own land. And ever since that concept really became a international norm, conflict has been substantially reduced. Because of that, there's a general presumption and a general idea that it's extraordinarily important, A, that countries avoid meddling in each other's affairs. And this is what creates a lot of issues, sort of like sovereign immunity, personal jurisdiction. And it's probably actually very accurate. And I think the severity of countries sitting in judgment of other countries' acts, laws, etc., is probably actually underestimated, the absolute importance of this. I mean, there was actually a Supreme Court case either earlier this year or last year that was litigated about, there was a citizen that wanted on their passport, instead of the word Jerusalem on their passport, they wanted the word Israel. And this was litigated because, the executive department was absolutely terrified about what the potential fallout could be about engaging in such a hot button issue, because naturally the other idea, what is Jerusalem, Israel, or Palestine. If what one citizen lists on their passport can be such a hot button issue, there absolutely is, significant fears about sitting in judgment about the acts of other countries. There was one case recently, or I guess a couple years ago. There was an oil company from California that was operating in Colombia, and they wanted to protect their oil refineries. I think it was Occidental Petroleum versus somebody. And in that, they engaged with the Colombian government, who ended up kind of just bombing some villages to squelch out the rebels. And it turns out they got the wrong village, and they didn't touch the rebels at all. And it was a massive humanitarian atrocity. And so naturally, this California oil company was sued inside the United States because you weren't going to find a recourse in Colombia. And the court also rejected it and said, we are treading on really dangerous ground if we were going to sit here as a court in California and state that Colombia is violating human rights, or Colombia doesn't have some sort of interest in maybe protecting itself against revolutionaries. Maybe they do, maybe they don't, but that is distinctly in Colombia's government's backyard. And just to add on to this, when it comes to this fear about foreign affairs, another extraordinarily important point, though, is that if there is to be meddling in somebody else's affairs, the courts are probably the last actor we want to do so. Foreign affairs are generally considered in the realm of the executive. It's a solitary office who has, the power of the State Department, et cetera, underneath their watch. And because of that, it should generally be the executive. Or, there's room for a Congress as well, to pass statutes. But it's particularly dangerous for the courts to become involved. So with that, we have been left with the modern principle of that, due to fears of international conflict and international incident, that human rights abuses essentially go unchecked. And this definitely, and the consequences of this has not been lost on anybody. And this is what my paper is about. That was sort of the legal background to it. And this is what is sort of, I find, just sort of extraordinarily interesting, is that now it seems like pretty much for the first time, parties are considering, how can we use arbitration to resolve human rights abuses where the courts have failed? And what makes this interesting is the idea that all of the problems that are wrapped up inside courts of law and why they're really poor actors in terms of adjudicating foreign rights abuses is mitigated when you look at arbitration, who are private actors. The essential problems with courts of law is they're public actors. They're branches of government. They're messing in political areas where they're not meant to be political. Arbitration, though, is essentially private actors. Not when a tribunal acts, they're not international tribunal acts, they're not really representing a country. They're just representing whatever organization they were contracted to belong to. They are, arbitration is based upon consent. So it's the idea that so long as the parties have consented to this private dispute resolution mechanism, all of the problems that we have that have led to, conflict should actually be fairly resolved. Now, part of it, and there is a lot of international and there is a tons of international conventions and agreements that basically state that, parties, countries, companies agree to abide by human rights. But the problem is that most of those are unenforceable. They're voluntary agreements. There's no mechanism that enforces these agreements. It's almost like a gentleman's agreement, and the only parties that sign them are ones who intend just to follow them anyways. What makes arbitration different, and for anyone who understands about the New York Convention, that's another international agreement that basically says that arbitral awards from international arbitral boards are enforceable essentially globally. Any country that has signed the New York Convention, and that's almost every country. And it's actually been extraordinarily effective, the New York Convention. It's so important in terms of international dispute resolution that the United States enforces these awards without question. Every country essentially does, because there's extraordinarily little discretion left to home countries about whether they can enforce these awards. So if you receive an international award, you go to whatever country that whoever lost, that panel, if they hold assets, and you basically say, we've got this award, and you're basically asking them to seize assets to fill this award. And it's been extraordinarily effective. So the idea about arbitration also overcomes the enforceability problem that has underlied most previous international agreements. That said, it still doesn't make very much sense why arbitration would work. And the biggest reason is because arbitration is a creature of consent. You have to consent to it. So if these companies who are operating in other countries are right now free of liability, it makes little sense why companies would then consent to liability. Hardly anybody, any rational actor, sort of the economics perspective, would ever create a liability regime when right now there's just free reign to act. And this is probably one of the reasons why this idea has largely gone unnoticed. But what happened was the Bangladesh Accord. As I said earlier, that there was a series of factory fires in Bangladesh, and there wasn't any recourse and there wasn't any remedies, and it really created this international outrage. Along with that, though, there was calls for creating some sort of international agreement that the companies who use the garment factories in Bangladesh would sign up with this, and they would agree to upfront costs. Like if you contract with the factory, you would actually have to monitor the factories to make sure they're up to certain compliance standards. And if they're not, you have to pay whatever it takes to remediate this, to bring the factories up to code. And also, if there is an ensuing disaster, there also could be tort liability that arises out of this. And naturally, the garment companies, a lot of them being sort of American or very popular, famous international garment companies or apparel companies, naturally said, just like everything else, why in the world would we want to sign this? The incentive is so low to agree to such an expensive and possibly costly regime. What happened next was fairly remarkable. The universities and especially university students, basically pledged that our student stores will refuse to sell the apparel by any company that has not signed the Bangladesh Accord. There is significant leverage. Like one thing is I went to UNC Chapel Hill. I mean, if you walk into the student store, I mean, it's the amount of goods sold by Nike and other apparel companies is absolutely not an insignificant number. And they're actually, and I believe, I don't want to get this wrong, but I believe that Cornell, for instance, dropped JanSport because they wouldn't sign the agreement. In result, there was enough leverage and enough arm twisting where actually a substantial number of companies have signed the Bangladesh Accord. When I mean substantial, I mean we're talking, almost all sort of the major clothing apparel manufacturers, and they have obligated themselves and they have put themselves in a situation of increased liability because there was enough demand. This is sort of a really interesting and and completely important dynamic that just occurred. This is about the first time when there was enough leverage, there was enough demand on the other side. And as it was probably mentioned, it was mentioned in the intros, I'm essentially a markets guy. I'm actually a big into economics. I love it. And this paper seems sort of like a deviation from markets, but it's not. It's just very sudden. This is one of the areas that I really wanted to discuss further, because I view this as a market supply. Previously there wasn't the demand. There wasn't the demand for this sort of mechanism. And the reason is because, people want human rights, but if you have to buy a sweatshirt for $20 and you can buy a sweatshirt for $30 that is guaranteed to be made under humane conditions, people have always still bought in the $20 shirt. They're happy to write a letter to the editor complaining about human rights, and that costs you the price of a stamp. But they're not willing to pay more. There's no clearer example of this than people who buy airline tickets. People, if you see a lot of times when there's an airline ticket that's $320 and the other one's $324, people buy the $320, and that's why we don't have snacks on airplanes anymore. It's the same thing with gas, driving across town to save 2 cents. So previously there just wasn't this ability there wasn't this demand. There wasn't actually the real demand to pay more. And for whatever reason, in the past 5-10 years, this demand for social responsibility, especially practiced by companies, has created this demand, and now the market is actually is complying. I have a good friend at Belmont University who is a former lawyer who writes on these issues, and his big area is social responsibility of the companies. Because now there's tons of social responsibility statutes where now companies not only have to supply, they don't have their fiduciary duty isn't even necessarily to supplying the highest dollar to shareholders, but actually it's also about companies like Patagonia have signed up where they said not only is it about the highest dollar for shareholders, but we can also exercise some sort of social responsibility discretion. That is now part of our model, and 37 states have adopted that sort of statute. And that might seem sort of like small potatoes, but it's actually pretty substantial, the fact that for the first time we have shareholders agreeing that some of their interests for having a top stock price can be subordinated to social responsibility. There's plenty of companies like Ethos Water and Warby Parker and Tom's that claim to have some, like, every purchase that you make contributes something, whether it's an item or some sort of money to this other cause. And this naturally raises prices. Anytime you buy an Ethos water, it's more expensive than all the other waters on the shelf. But for some reason, people are now valuing this to such a degree where people are willing to pay that dollar to actually exercise some sort of consciousness. And this is what sort of makes the Bangladesh Accord so groundbreaking, is in the sense that this demand has grown to a degree where the leverage has sort of overcome the prior pushback. And this isn't the only example. Since then, now the International Olympic Committee, following a lot of the alleged human rights abuses in Sochi, have now in the contracts for future host sites includes a human rights clause, which is enforced by, I forgot the exact name of the organization, but it's like the International Arbitration of Sport or something, is a name similar to that. And so that is a similar example. And there's also been proposals that is going through the UN about possibly creating some sort of sitting tribunal. And now the suggestion is at the Permanent Court of Arbitration, where it would be specially situated to hear human rights disputes that might arise to resolve disputes using arbitration that incorporate human rights clauses. So this is a really fast-moving sort of modern take to this sort of historical problem. All of these events have really been occurring in the past year or two. So, if you would have tried to write on this topic about 2 years ago, there would have been nothing to write on. And this is what makes this, these developments so interesting. And before I go farther, there is one thing I do want to mention, is that a lot of companies, even though they're the ones accused of violating human rights, they're not necessarily trying to do this. Assuredly, there are some companies and actors who are, for the most part, indifferent. But there also is a fair amount of, I think Occidental Petroleum, I think they were one company that basically said that we didn't want to hire the paramilitary troops that we were required to use. A lot of companies are being sort of finagled into an agent-principal relationship with like security companies, et cetera, that they would rather not work with. But a lot of times it's just sort of a term of a contract. I believe one similar one in Indonesia, there was an oil company that was, that they basically hired a paramilitary. If you read like the facts of the case, it looks horrible. Because you read about how the plaintiffs allege that this oil company hired, I think it was Exxon, or I guess I shouldn't guess out loud, but it said had to hire this paramilitary company that had previously committed human rights abuses and then predictably did so again. And the government is protected by sovereign immunity, and the company is part of their argument is just that this wasn't our choice. This is sort of what's pressed upon us. And so now, taking this to the next step, now that I was saying that we're just about a year and a half into this, or a couple years, so there's a lot of unanswered questions. And so part of it was I was going to sort of address sort of the updates and sort of what we know. And what we know is not much more than we knew just recently. I've been in contact with the executive director of the Bangladesh Accord because I was very interested, because when I first talked to him, it was just starting, and there had yet to be factory inspections. And since I talked to him, there has been no disputes that have been resolved by arbitration yet. And so what do we know? First, you could just say, well, it's simply early, There hasn't been time because, there is due process, there is a process, because you could make the easy assumption that, well, it's ineffective because nothing has gone to arbitration, so obviously there isn't the power. The second idea, though, is that maybe it is incredibly effective, and that's evidenced by the idea that there has been a lack of arbitration. Because if you think about it sort of economically, just what are the goal of laws? If you think about the idea of like DUI laws, well, the goal of DUI laws is not necessarily to throw people in jail for driving under the influence. A big part is it's supposed to raise the cost of a behavior. The idea under DUI laws is that people who go out at night, who might otherwise decide to drive home after drinking a little too much, would otherwise consider, well, I can't go to this will really hurt my chances of going to law school if I get a DUI. I heard the average DUI costs about $10,000. For all these reasons, I would rather spend $10 and get a cab. So the true goal of laws is deterrence, is to raise the cost so a rational actor who would otherwise choose option A would instead choose option B. So there's a perfectly good plausibility that companies are choosing, they're complying with the Bangladesh Accord in ways that maybe previously they wouldn't have. And the problem with knowing the answer to this is it really demands a counterfactual world, which naturally we don't live in. Understanding sort of what would this world look like had there been no Bangladesh Accord? Would we have had another factory fire? Are companies complying because otherwise they wouldn't have, but they understand there's this dispute resolution mechanism that is, so powerful. Other questions that it says, let's just even say the Bangladesh Accord is, just for argument's sake, let's say it's wildly successful and it really is affecting how companies are doing business. And in Bangladesh, because that's the only place where it governs is Bangladesh, is let's say that, the standard of living for a factory worker is now safer and it's better. But this still raises the question, is this just a one-off experience? What are the odds that, with universities, because universities are just known to be the centers of like social consciousness and student activism, in a place where people are, spending a lot of other people's money, so they don't care if things would cost a couple dollars more, and we're spending student loans. So what are the odds that, this sort of, wonderful mix of social consciousness, demand, can sort of foment in other areas. Most of the human rights abuses that you'll see have come out of the oil and energy and mineral extraction industries. It would be great if that would be an interesting. That'd be great if there could be another, venue where you would find something like the Bangladesh Accord, but it can be difficult to really, really convince yourself that same sort of like real demand is there. To the degree that we are willing to drive to the other side of town to save 3 cents on gas, what is the real political will to raising the price on gas, to create liability for energy companies? So that's one thing that really I've racked my mind with, is understanding maybe the water industry, et cetera, where this could be a reality, because there is the distinct possibility that this could be sort of an isolated incident, despite some evidence that it is becoming more popular. Another area where this is becoming perhaps more popular is actually with international investment treaties, international investment agreements and treaties. Right now, it's a really encouraging sign that, especially in like the preambles and at the beginning of a lot of these legally enforceable documents, it says the parties agree to abide by human rights amongst each other. Well, the preamble is not legally enforceable. That's not what you can go to arbitration over. But you are starting to see, kind of for the first time, these terms being inserted into like the introductions, and so it'd be interesting to see how they maybe can mitigate, how they can maybe flow or into the actual operative body of the document. And one thing that may really help is the proposal for the Permanent Court of Arbitration. Perhaps one reason why you were not really seeing further movement is once, we agree to put arbitration clauses in these documents. The next question is, so what arbitrator do we use? There isn't a natural, there was one statement written in an article a couple years ago that essentially said human rights standards have never been enforced by arbitration. So with that in mind, who are you going to use? Thus, there is no arbitrator who has ever walked down this road. So potentially, if this proposal had gone in front of the UN and is now in front of sort of the idea about using the Permanent Court of Arbitration actually becomes a reality, then it actually could potentially become a greater reality, because now you actually have a body. You actually have some sort of usable court system not a court system, but some sort of panel organization that would be able to execute these agreements. One thing that I found also significantly interesting is that talking to a couple of the experts on this, there's also the idea is, could this possibly be undermined by the arbitrators themselves? In the sense that this is nothing that arbitrators have ever really done before. This isn't really part of their mandates. And maybe they're actually not particularly happy about this. And so when you say that arbitration could help resolve human rights disputes, it's more just like a procedural thing. Like maybe there actually could be a room where people could argue this. Right now, procedurally, in courts of law, they're always defeated. So you're saying that this could at least overcome the procedural hurdles. But even when you overcome the procedural hurdles and you find somebody who says, I'll listen to your claim on the merits, there still is the problem of saying, proving your case on the merits. There are certain claims out there that are substantially difficult. And there is some suggestions from some of the experts that I heard that potentially arguing cases on the merits might also be extremely difficult for certain injured parties, for simply that matter, because maybe arbitrators they're not used to this, they don't particularly want to hear these cases, and which is partly influenced by, if you think of all the parties that are affected by this proposal, most of them are actually, this doesn't really help them. This helps victims, who are, for the most part, not really the most powerful parties. Developing countries are not really in favor of this. Obviously they're running regimes a lot of times that helps encourage these abuses. Companies want this the least. Because again, you're creating liability where liability doesn't exist. developing countries aren't always incredibly happy about this because, they're representing, for the most part, the companies that really don't want this. So you also have a suggestion that political demand is a lot of times just by the victims. And for the first time, you're actually seeing it to a degree from the consumers as well. And what will be sort of interesting is to see how much inertia is built against this. And it seems at first blush like maybe too much. And the only thing that suggests maybe it's not too much is the evidence on the record, which is actually very promising when you see the amount of organizations, contracts, et cetera, that are for the first time including these terms. And without these sort of the evidence of these contracts including these terms, it would actually seem implausible. And that's the one thing that I always need to come back to, despite all the pessimism about this being a large regime, is the fact that there is evidence that this actually could be a thing. And so with that, I'd be happy to discuss this. Questions, comments?
I've asked our speaker to repeat the question if somebody has a question.
Oh, thank you. Forgot about that. Yes?
I think I might have a counterfactual for you to play around with a little bit. Many of the items you've talked about in the context of college stores and so forth, these are easily interchangeable items. It's easy to replace one sweatshirt with another sweatshirt. This is different. iPhones. You've got human rights abuses in the manufacture of personal electronics. But where fashion is perhaps less of a factor in the college store case, here you have an item that is almost a monopoly product, has this kind of human rights movement. And this is fascinating because this is really almost elective affinity between boycott and arbitration. Has that been seen at all in the area of things like personal electronics?
So the question was whether this has been seen sort of more in like monopoly areas where things, and I think that's like personal electronics, where there is more monopolies about it. And I think that's the point where things like clothing is sort of interchangeable. And I think that actually raises a good point, because again, I always like to think about the economics of it all. And I think that it is probably much less likely to see in any area where there is something close to a monopoly or just a few dominant players, because you do need that. You need the idea of sort of adequate substitutes, because quite frankly, you can go in the student store and there's many brands, and so it's easy to say Jansport or so ever. But if it actually were to come to the point where, like, who's willing to go without a phone? Who's who wants to go back to, who's happy not to use an Apple product or some other product, and probably significantly less, because I think you're saying that the cost of being socially conscious becomes much greater when when you don't have an adequate substitute, when you're effectively giving something up.
Precisely, because if you buy into this particular electronic ecosystem, it's very difficult to substitute something else. And where fashion might have been a useful force in the sweatshirt case, it becomes a counterforce in the iPhone case.
Right, yeah, and I think you do have a point there that it might almost be sort of like a necessary ingredient, where you have enough producers where you can almost eliminate some, and it's not going to affect the buyer, to some sort of substantial degree.
Yeah, just a technical question. I'm just looking at the accord.
Okay.
I don't see any choice of law provision. I don't see it will be the law of the company that is entering. I don't see it will be vested on. I see that there's a reference to uncontrol. Does that specify the rule of law, or do you get to the arbitration, which hasn't happened yet, and then I say that the plaintiff, the labor force says U.S. law applies, and the corporation says no, we're doing business in Rwanda, so Rwandan law applies, and there's no liability, and so you then wind up in this
Well, I'm glad you pulled it up, and that actually has been a criticism that I've heard, is that it's that some of the drafting. Sorry. The question was basically, what's the choice of law? What's the law that would be used? Because even though it's a contract, there still is the idea of contract law, and that actually has been a criticism that I've heard many times, is that several key provisions are missing or sort of absent, and because I believe it says with unitrial that it says like it will use arbitration. I think it says in accordance with, those standards, but it doesn't actually even provide which arbitrator will even hear it, and that's kind of problematic, because if a dispute ever does arise, what terms, but how do you know actually who to use? And especially for scholars of sort of American arbitration, which this is not, but it should be mentioned that which arbitrator you use can have significant effects on how things change. So it almost requires sort of like an ad hoc agreement between parties about where to go or which body of law to use. Because I agree with you, I don't believe it mentions that, and so I've always sort of harbored personal curiosities of part of the reason why there really hasn't been why parties haven't gone down this road to arbitrate this is because the controlling document doesn't provide a ton of guidance. So I always feel like it will have to be kind of decided ad hoc, but that's a really, really important thing. That you notice, because even when you say, well, what's the problem? We have this document right here. We're gonna solve whether you've complied with this, but there still is plenty of legal standards about who might have the burden of proof and damage. How do you count damages? I mean, that is the heart of contract law. I tell my students this when I do contracts every time, that damages is where the beauty of contracts comes out, and that's why you leave that for the last day. But that's sort of the wonder of contracts comes out in damages. That's my favorite class to talk about. And if you don't have a document that tells you how you count damages, essentially what I think it says, any dispute goes to the steering committee, and it's only problems, it's only disputes that come out of the steering committee go to arbitration. So arbitration isn't your first step. So presumably the steering committee, I would hope, would have some sort of mechanism to resolve this. But still, any good contract should settle this ex ante.
Well, I had a little more basic question.
Yeah.
I'm not familiar with the Bangladesh Accords, and what I was thinking was, what is it that, for example, a U.S. company would agree to arbitrate? What circumstances would they agree to arbitrate that would find its way into these accords that then you can get into an arbitration system?
Okay.
Is it worker safety, worker conditions of employment? Okay.
The question is what sort of things would be arbitrated underneath the Bangladesh Accord? What would be agreed upon? And there's a couple steps. And it's actually one of the problems that companies had about it is they say that the potential for liability is absolutely substantial, because part of what it does is there's sort of an affirmative duty to monitor the factories to make sure that they live up to a certain code, and that is one thing that they actually have, and they actually have some independent teams of inspectors who are going from factory to factory to find out whether they're up to, some sort of internal code that they have. And upon a finding that, if a certain company uses a factory that's below code, it is an obligation of the company to spend whatever resources to bring it up to a certain code. So a prime area where you would see some sort of arbitration would be if you were to hear, like, not only is this factory, ripe to burn down, it doesn't comply with handicap standards. And that might be that last thing with, like, you might have comes like, whoa, we never talked anything about bringing it up to, that sort of standards. And that would be the sort of thing that after it goes to the steering committee, it could come to, it could go to arbitration about whether, certain.
And the arbitrators could order that compliance be had.
Yes, and that's one of that's sort of the brilliances of it, is because under the New York Convention, that their findings would essentially be would be binding, and especially if you have a company, and because it actually And one thing that's also the Bangladesh Accord does do pretty wisely is it obligates companies that contract with the factories. So it's not just the Bangladesh factories that are underneath the accord, but if you are Nike and you're running a factory in Bangladesh, you're contractually obligated to make sure that factory is up to standards. And because of that, if you have an adverse finding by an arbitral tribunal against you, you can take that award to the United States, and whatever these injured parties can start picking stuff out of Nike Town to satisfy their awards.
I can understand that. The follow-up question I have is, what if the company is ordered to comply with certain standards, and what you have as a consequence is workers are injured, there's a fire, etc. Does that fall under the arbitration?
The question is whether with fires or injuries afterwards, does that fall into the Bangladesh Accord? The answer is yes. And that is part of the reason why companies were particularly scared of that happening, because you have these old factories that even if you bring up to code, it can be hard to monitor the managers and the supervisors that are actually running the companies that oftentimes can lead, to the dangers. And a lot of companies said there is essentially unlimited liability. There is no cap to liability in the Bangladesh Accord. There is the potential for ruinous liability, by complying with it. And but nonetheless, if you take a look at the companies that have signed it, it's quite incredible to see, and it's even companies that have not that do not make college apparel. Like I'm pretty sure like H&M signed it, and I would hope that all the companies that signed it actually have work in Bangladesh, because if not, that's a pretty easy sign. Yeah.
Is there any sort of data on whether companies have left like Bangladesh or because of this?
The question is, is there any data or any sort of evidence about the companies that have left Bangladesh because of this?
Maybe brought jobs back into the United States or to another industrial country?
I was thinking about that earlier today, and I don't particularly have an answer. I think one reason why the Bangladesh was particularly successful is because it's pretty hard to move factories, just sort of overnight, move whole production lines, especially like companies like, I think Adidas signed it. I mean, they have a substantial production line. So suddenly just picking that up and then moving it to Latin America would be, it's almost cheaper just to sign the Bangladesh Accord. But I would have to think that, especially some of the smaller operations, companies they've had to at least consider it, because I don't believe there's any sort of penalty about leaving Bangladesh. And, but I haven't. That's a really good question, and
there's got to be some analysis within the companies. What does it cost to bring it back to some other country or to bring it back here? And our obligation is to shareholders, so and that's profit. So I could see that there's really an ethical question in here too.
Yeah. And one thing is, there's just not a lot of literature on this. I mean, the way I even found out about this was an absolute chance encounter. I mean, there's not much discussion. I mean, I only learned about this because I was playing basketball with one of my friends who worked for the trademark office at my university, and he just simply mentioned about, and somehow I told him I'm interested in international human rights and the role of businesses, and he said, well, things must be easier now with the Bangladesh Accord. I'm like, what? And he was like, yeah, and he, like, all he does is work for the trademark office in the company. He's like, well, yeah, it's like, these companies just all signed this agreement, to supply us clothes that they have to follow the Bangladesh Accord. And I was like, those things just, I mean, those are all like, because I'd never heard of it. And it's like, those things are all just empty promises. Don't believe the hype. And he's like, no, I heard this is good. This is like arbitration. And I was like, when he said arbitration, you're like, that would be enforceable. I wonder if there's ever, with those, I mean, there's so little discussion or writing about it. Like, the only reason I learned about it was an absolute, like, just happened to be in the right place, talking to the right guy at the right moment, Yeah.
I just two medium-sized points.
Okay.
One, part of what it looks like is in the Bangladesh Accord, which I didn't notice in your paper. It's not just the arbitration, but it's the duty that you mentioned in advance to work with labor to set up standards.
Yeah.
And to the extent that you don't see accidents, I can imagine that is doing more of the work than the threat of liability itself.
Oh, yeah.
There's a lot of academic literature about corporation, individuals, people, corporations following contractual commitments. plus any half-decent lawyer looking at what a company that might be setting up overseas wants to know, okay, well, we have these obligations. We could face potential liability if we don't do this. Let's comply with you. And so once you're engaging in these positive practices that make the factory safer, to what degree do you think that arbitration is doing the work versus the contractual commitment to work with labor to make this factory safer?
That's a really the question or the comment was essentially about not just at the threat of liability, but where the odds that there's just these contractual obligations just sort of create positive practices, and sort of compliance. And I think that's an excellent point. I should actually. I would love to add, and I will sort of add that point to the paper, and also I could run it by. I have a colleague who actually works a couple hours away at UConn, the UConn School of Business, Robert Bird, and he's also I think a fellow BU grad, and he does a lot of work on compliance. And part of the interesting that he looks at compliance is sort of the optimal levels of compliance, and so what level of at what point is compliance too much compliance when it's sort of every dollar you spend towards compliance not gaining a dollar back of limited liability. And does very interesting work about that. And so it's definitely something that's really worth incorporating as the idea is what are the odds of just signing this document and thus putting in sort of putting in a little framework of how are we going to follow the Bangladesh Accord. It could just take a lawyer an afternoon to just say, okay, let's just do these couple of practices. But those positive steps could actually have, substantial, it could just be testing, making sure once a week the fire detectors are, working, and just having that little clause in there can do a whole lot more than the threat of arbitration.
Not locking the doors for workers.
Yes, not locking the doors when the workers are there because it's a little cold, so you want to save heat, or making sure they don't leave.
So the second medium-sized comment is in the second to last section when you're talking about potential future uses of arbitration. I realize this may be a little bit far field, but you're focused entirely on the corporations. Mm-hmm. Whereas part of what you're saying is that when corporations go overseas, they're somewhat limited in what they can do, in the sense that if you're essentially forced to hire a paramilitary group, which may or may not be owned by or yielding dividends to people that who are in the government, I'm wondering to what degree could arbitration be used with the government itself? So the government presumably wouldn't sign, although I can imagine some companies would have enough sway that they might be able to get a corporation to sign an indemnification clause of some sort. I don't know if we see that. And then does indemnification get enforced in arbitration? And then relatedly, to what degree with the World Bank, for instance, or other International Monetary Fund, is there any possibility of tethering loans to a commitment to use arbitration for certain types of abuses?
Okay, the first comment was about the idea about what actually could the sovereign, who has generally enjoyed foreign sovereign immunity, be able to be sort of tied in, because as we mentioned, a lot of times the companies that are accused of human rights abuses are actually being accused because they're in an unwanted agent-principal relationship with a paramilitary force that they never wanted, that they are, it's just like a really bad family member in your family who's going to do dumb stuff and drag you down with it, and there's very little you can do about it.
And just to be clear, I'm assuming both arbitration clause and waiver of sovereign immunity for claims X, Y, and Z.
Yeah, and there's actually there's a work done by a professor, Roger Alford, and he published something in the Notre Dame Law Review that actually touches upon that. That's one reason why I steered very heavily just to the corporate area, is because it was sort of, I haven't read this paper in a while and I should have brushed up on it, but it was his idea that you could actually bring, I believe the paper is called Arbitrating Human Rights, but you could actually bring corporations into the scope of actors who are punishable when otherwise they'd have foreign sovereign immunity because of, but I think that was also written at a time when before the fall of the Alien Tort Statute, when the corporations were also being held, had a possibility of liability. So this is sort of the next generation when now the companies aren't even being, but that was one reason why I sort of steered away from that, because, considering that he wrote a great paper about that, tried to focus it sort of down that line. But related though, but I also thought that understanding the relationship between the company and the country, especially with these security contracts, was a substantially interesting topic. So I actually kind of left that alone so I could write about that, because I thought one thing that would have been a fantastic paper, and I don't know if I shouldn't be telling the world about this idea for a paper, but here I go, is I thought that it would be really interesting to actually study the contracts and to understand how these contracts are drafted and how liability or potential liability is apportioned between parties. If you could even, to some degree, predict where human rights abuses arise, depending on, and the problem is, find me a company that's willing to give you the contract, And so I had this idea that, if I could get these, and I really burnt a lot of rubber emailing people, and people were like, yeah, it sounds interesting, but I don't have the contract and no one's going to give it to you. And as it turned out, they were all right, No one was willing to give it to me. And it just became one idea that, will probably never get exercised. And, and if you are coming, why would you give it to somebody like me? I'm sorry, and what was your, the second point was about...
working it into International Monetary Fund or World
Oh,
Bank.
right, and that was the other, and that's sort of the other question is could the International Monetary Fund, impose that sort of condition? And I think that's, a condition of arbitration, and I think that's extraordinarily possible. Sort of tying this idea that if you accept our funds, you agree to arbitrate, future rising human rights abuses, and I think that's not dissimilar than what's happening with the Olympic Committee, sort of an international committee saying that if you want this benefit, saying, I guess, as we see these empty stadiums all over the world, the magnitude of this benefit is dubious. But still, if you want to host the Olympics, you sort of open yourself up to this possible liability. It's not great liability, just don't commit human rights abuses and you won't have liability. It's not a huge standard to follow, but nonetheless. And I think if there is something like if there is a permanent arbitral court, like something like the Permanent Court of Arbitration that's willing and has expert arbitrators willing to adjudicate here human rights abuses, I think it becomes a lot more likely, because I think that's sort of the question. And I think, as you pointed out earlier, that was sort of something that the Bangladesh Accord suffered under. There just isn't this panel, there just isn't this mechanism, and because of that, it wasn't drafted into the Bangladesh Accord. Sorry, did you have a...
Oh, yeah. I have a question just on the business side of things. We were talking about the demand for corporate social responsibility kind of up and coming and growing. Do you think, well, I guess, what do you think has led to that? Has it been social media, or what has kind of been the driving factor behind that demand?
Oh, that's a really good question. I mean, the question is, what is sort of the driving demand that has led to sort of this modern idea of social corporate responsibility, sort of in a way that has never previously existed. I mean, and when I mean never, I think never previously existed. And, part of it has to be, sort of the increased wealth and it can be easy to miss sort of the increased wealth and sort of prosperity of the country to the degree that politicians have a lot of incentive to tell you how bad things are. And because, if you're running an election, you don't want to say things are great and I promise to keep them great the way they are. There's a lot more incentive to say I will fix all that hurts, and so I think that just the fact that, but you're right. I mean, possibly social media. I feel like a lot of this maybe even started a little before social, because a lot of the initial sweatshop protests, started occurring before it. I mean, that's a really good question. I mean, there was a lot of course, everybody knows the golden age of protesting in the 60s, but there wasn't really this boycotting, putting our money where our mouth is. And I maybe it was just an idea that no one thought would ever work, and maybe it just takes that first company to see if it works. If anybody, and I think that is actually an area where I struggled in the paper, is to explain, because I said there's this new phenomenon where this is happening, but saying, and I think it was sort of glaringly missing, why it's happening now and not necessarily what was happening in the 80s, I mean, was it the 80s just a terrible decade, and it just so happened it had to wait a decade until it happened? But it's sort of a good question why suddenly we don't necessarily care as much about, the bottom dollar quite to the degree that we once did. I mean, it quite possibly is just this feeling. I think that there's been a lot of good discussion basically saying that if you purchase this, you are complicit. If you purchase this, you are part of it. And I think that's maybe a lot of how the dialogue started that sort of changed into behavior.
I guess, just to maybe contribute, I think it's an interesting question for another topic, but when he was referring to the phenomena of what are referred to as B Corps, benefit corporations, which he mentioned have been passed in like 37 states, and the effect of incorporating under that statute essentially allows managers to make expenditures that they might not otherwise make, and takes away the power of shareholders to force those managers to maximize profits. Basically saying, no, we're a benefit corporation. It's built into our charter. We can also not just maximize profits, but we can try to maximize the social good at the same time. And so the question is, where did these arise from? And my theory is that a new generation of entrepreneurs, who are not going to law school to change the world, but are going into business to change the world, realized that this was a barrier to changing the world, and they needed the protection of these statutes. So I'm thinking that had to be part of the impetus, was basically a new generation of entrepreneurs who not only want to make a good product, but want to make a good world. So that's my theory.
Yeah. Oh, and also to piggyback onto that, I think as a legal profession, we're to a large degree to blame for how slow that actually has been to develop. And if you think about, if you're a lawyer, because I used to do transactional law, and when somebody asks you to draft this document, your goal isn't always to be innovative. In fact, your goal is generally to be conservative. Because if you do something innovative and you mess it up, that's malpractice. If you do something conservative and it messes up, that's not malpractice because you just followed convention. And so I think to a large degree where people said, I'm Patagonia, I'm this company, and I want to structure it, in a way that doesn't necessarily marry fiduciary duties between shareholders and boards, there's a lot of lawyers who are don't want to get sued. We have a bunch of other documents that went the other way. Can we just run one of those? It'll be cheaper. And so there's a huge transaction cost and a lot of sort of inertia, especially from the legal profession, to not do things in the more traditional sort of conservative way. Yeah.
So this is something that I didn't pick up on in your paper. There's a spreadsheet online which has factories that have signed the Bangladesh Accord.
Yeah.
They're all in Bangladesh. And I didn't realize that the Bangladesh Accord, it only applies to Bangladesh, is that right?
Yeah.
Okay.
So the question, it only does apply to Bangladesh, but it applies to Western companies contracted with the factories in Bangladesh.
Right, but you could imagine that creates a potential, not quite a race to the bottom, but if a Chinese factory doesn't require you to sign any safety agreement, then you could imagine investment in Bangladesh dropping.
Right, and
and so it's unless it creates some sort of an international floor, then there's the risk that it doesn't. This is for the final section of the paper, potential problems, and I sorry if I missed it. But
No. Something we sort of talked about. It was this creates a race to the bottom because all you have to do is have a country that doesn't have a Bangladesh Accord that offers the zero liability. Come here, open up shop, please.
Right. And your point that companies have a lot invested in these factories, and it's not as simple as turning off the light. That's I think a good response. But I would just be a little clearer in the paper that right now it only applies to Bangladesh, and perhaps the next movement is to try to make this an agreement regardless. It's interesting. One thing that you might talk about actually in the second to last section is the idea of a unilateral arbitration clause. So it's not we agree with this factory in Bangladesh, but we agree that if you buy a Nike product, wherever we are, we will agree to universal arbitral jurisdiction. And so this idea that it doesn't matter whether we're doing business in China or India or Bangladesh, we agree to work with labor to make factories safer in accordance with the Bangladesh agreement, and we agree that we can, and then step 2, we agree that there'll be this dispute resolution mechanism.
Right, and I agree. It is sort of it is extremely costly to just take your operation out of Bangladesh and just move it continents away. But at some point, when you're facing unlimited liability for in perpetuity, at some point it does become, part of the equation that maybe we are better to open up in a place where business as usual was, quite lucrative. And one thing I also want to mention is this idea of it not just being a strict shareholder board relationship. That's something Europe has actually been doing for a while, the idea of the stakeholder. But to the degree that most companies do follow the board and shareholder model, where the idea is about earning, promoting shareholder value, it's really hard if you're a board not to consider moving. I mean, you could personally love what the Bangladesh Accord does. I mean, you could be all for it, but to the degree that you have fiduciary duties to your shareholders, I mean, how can you not consider that and abide by your duties at the same time?
Yeah, there's a 34-page spreadsheet of factories in Bangladesh that have signed on with phone numbers and contact information. So just as a follow-up,
interesting.
In a couple of years, you could see how many of them are out of business. How does that compare to a typical rate? Can we infer that there was any harm to companies from signing this, or perhaps that there was even some benefit?
That's a fantastic idea. I should download that right now so I can capture who it is.
Well, thank you very much, Professor Day. Can we give him a hand? He's certainly free to answer questions, but we are at our 6 o'clock hour. I like to release the captives, the ones who've been courteous enough to stay. I do want to make an interesting point. I love this topic. I love the idea that it did not come through a traditional route. In this sense, Professor Day is unusual. Usually our speakers come from law schools or from law practices, or they themselves are neutrals. They're all, mediators, arbitrators. But the idea that this was really this unusual application of arbitration actually was brought to our attention by a lawyer, but he teaches in a business school. And in fact, the only way he heard about it was by going to his local academic and having a friend of his saying, "Gee, have you heard about the Bangladesh Accord?" So of course he hadn't, and nor had I. But now we all have, and I guess really the interesting question is this a harbinger of things to come, or is this just a one-off, and only time will tell? So thank you very much.
Thank you.